Hello and welcome, I'm Shola Shieli. The global pandemic COVID-19 has fundamentally and maybe even permanently disrupted all human activities, and it's for this reason and more that a group of like-minded senior lawyers are championing the use of technology to facilitate continuity of court business. The chairman of the governing board of the group, Justice Reform Project, Mrs. Funke Adekoya, Senior Advocate of Nigeria, is one of our guests on this episode of Law Weekly. Funke has over 45 years' experience in litigation and arbitration and is widely recognized and respected locally and internationally. At various times, she's been adjudged the most outstanding female legal practitioner in Nigeria, and her opinions, especially on legal issues, are widely sought and considered very weighty. I began our interview by asking her views on what the legal community in Nigeria is losing as a result of its snail speed in embracing technology.
I think the first thing is that dispute resolution is not for the legal community. It is for the public. So I'd rather start with what has the public lost. People have cases in court. Landlords have tenants they want to evict. Companies have disputes. International companies have disputes against Nigerian companies and vice versa. Domestic violence, marriage, divorce petitions are pending in court. Everyone wants a resolution of that problem. That's what the public have lost from this shutdown. Because for 5 weeks, courts have not been sitting. Even matters that have been concluded before the lockdown, we're waiting for judgments. We're waiting for rulings on applications for injunctions, applications for bail, all these things. So the public has lost. Before we even talk about the legal community has lost, because we're not going to work, so we can't pay our staff, we can't access our clients, so we can't get money from them if we're not doing any work. But I think the focus is not so much what the legal sector has lost as what the public have lost.
The secular shutting down courts for some time was actually exempted urgent matters,
time-bound applications.
Yes.
But what is urgent? As far as a litigant is concerned, he has brought his matter to court. It is urgent. So it's a vague phrase that allows the judge concerned to decide on what is urgent.
That's not clearly spelled out.
It's not clearly spelled out. And then when you have a situation where, for instance, in Lagos State, even before the lockdown, the complete lockdown, the junior staff were stay at home because they were the ones who would come in public transport and would be more easily be exposed. So how could the courts really run in those circumstances where there's no court clerk, there's no court registrar, where you go to the registry to file and the junior level of staff are not there to accept processes? So it's been difficult all around. On paper, the courts were open for urgent or time-bound applications. But in actual fact, they were not.
Yeah. Now, one of the things that you and the JRP suggested was that practice directions departing from the normal should be issued by heads of courts to bridge any gaps. You specifically said that in anticipation of times like this, the Federal High Court rules and that of the National Industrial Court of Nigeria, for instance, contain provisions enabling same. So what would be your comments to lawyers who say that virtual hearings, remote hearings, e-proceedings are not proceedings in the open? They are not constitutional, especially when you consider Section 36, subsection 3 of the 1999 Constitution, which says that all proceedings must be in public.
I'm sorry, I beg to disagree. Because what the Constitution means by it should be in public means the public should have access. All you need to do is to publish the invitation to go online on the judiciary website on a day-by-day basis. And then anybody who wants to listen to any court proceedings, you click on the link and you can listen. So the access to the public is there. You don't have to be physically present in a building. In the same way as we are saying virtual hearings, you don't have to be physically present to have the court. So the public doesn't have to be physically present once they can access the virtual courtroom. And all you need is that link.
So does this mean then that there's no need to amend our laws, especially the Evidence Act, where in terms of fair trial of an accused person, cross-examination, tendering of evidence and exhibits, trial within trial, etc. There are people who say that this cannot be done by e-proceedings.
I beg to disagree. The technology differs from how it can be done in terms of accessibility to the electronic copies of the various documents. But online technology allows for various screens to be online at the same time. So the prosecutor, wherever he is, can see the accused person, can see the witnesses that he's calling, and the judge can see all the parties. So I don't see how this issue of it's not possible. The worst people could say is, we haven't tried it. And thankfully, probably within the next 2 weeks, the GRP is actually organizing a virtual court hearing.
A mock
Court hearing in Nigeria. And we're hoping to invite as many lawyers who want to access that platform, and hopefully judges as well, to see that it can be done.
Will it be open to members of the public so that we can test that as well?
Yes, it will be open to everybody to see how it can be done. I hope the judges will also see that it can be done. Although in light of the last directive from the CJ of the Federal High Court, I don't know whether the Federal High Court judges would want to continue. Those who have actually started using Zoom and other online platforms will feel confident enough to continue.
I'm sure it must come to you as a shock then that the CJ of the Federal High Court, Justice Soho, by a circular dated 29th April, directed all judges of his court to refrain from introduction and application of technology until there is explicit approval from the NJC. Because even you say that the Federal High Court had already made provisions for this.
Well, honestly, I confess to being both amused and bemused when I read that circular. Because the Federal High Court is a court. The head of that court is the Chief Judge of the Federal High Court. Now, if he wishes to defer to the head of another court, which is the Chief Justice of Nigeria, making practice directions for his court, maybe that is the way he sees it.
But
and
that's
I think
not the way
the way it should be. I don't think that is the way that it should be. Each court is independent in the sense of the CJ has control of the Federal High Court and the CJN has control of the Supreme Court. I'm also a bit unclear as to the powers of the CJN to direct by way of a practice direction all courts, which was where we started from initially, and that's why we are where we are now, where the CJN said all courts should be suspended.
He can't make that in his capacity as chairman of NJC?
I have not seen where the National Judicial Council, the structure and the policy, gives such powers to the NJC or to the chairman of the NJC to direct proceedings, even in state courts. I haven't seen it.
So, but for those who say that this remote virtual hearings, it is elitist, where are we going to get power supply from? What about the lawyers in Adekoya, in some rural communities in Okitipupa, in some far-flung places? It's elitist. It's the lawyers in Lagos, Port Harcourt, and Abuja who get fat briefs and fat clients that can afford to go online. What would you say to people like that?
First of all, let me start with the cost. It's probably cheaper at the end of the day for me to be able to sit in my house or sit in my office, properly dressed for court, and access an online platform than for me to put my car on the road, buy petrol. If I have to get a driver who will then drive me to the court premises. So at the end of the day, the argument about it's more expensive, because that elitist gives the impression that it's for a particular class of people. If anything, I think that the use of online technology democratizes the court process.
We've seen a flurry of activities from the AGF, from the heads of courts on this issue of remote hearings. I know that Lagos and the Court of Appeal have issued practice directions.
Yes.
And I'm sure that you've seen them.
Yes.
But do you consider them far-reaching enough?
No, they're not far-reaching enough, but it's a start. Even though there are issues with the protocols that have been issued, both by the Lagos State High Court and also by the Court of Appeal, but at least it shows that the judges are thinking. By the time the legal community starts to critique those protocols and show where there are problems, then I believe the CJs of the various courts will refine those protocols and make them fit for purpose, to the extent that they are thinking and they're saying there is a solution. it's a step forward.
But what ideally should have been?
There's the question of online filing.
Okay.
At the moment, I think it's called the Judicial Information System, Lagos State System. The way it works is, prior to the lockdown, you go physically to the court. You file your hard copy, and then you take another hard copy to the e-filing section, and you deliver it there. And I think they then scan it into their system. But when you get to court, you still use paper documents.
Even though you've gone to the e-filing section.
Exactly. The judge still says, your processes are not in my file.
So that means it's not working.
As far as I'm concerned, it's not yet working. And even in the protocols that we have seen, the protocols say you will file online. There's no address. There's no email address that we're supposed to submit our filings to. There's no WhatsApp number that we're supposed to upload those documents to. It merely says it should be PDF. To where? So those are the gaps that, as we start to critique the protocols, they will come out and hopefully be remedied.
Finally, JRP has written to the Chief Justice of Nigeria to express reservations about the approval for the appointment of judges. I know that, amongst other things, you made a freedom of information request.
Yes.
Can you tell us more about that?
Well, one of the things that the Justice Reform Project is about is transparency in the judicial system. And this is in line with the national judicial policy, that appointments should be in a transparent manner. And they have guidelines as to the process. Now, one of the things is that everybody should have an opportunity for applying to be a judge. I never heard, I'm not interested, but I never saw on any platform that there are vacancies in this.
So it should have been advertised?
We think it should have been advertised.
Okay.
And we'd like to ensure that the judges who are appointed are fit for purpose. And that's why we've made this freedom of information request, to have the CVs of the 70 judges who have been proposed or recommended for appointment. Where are they from? What have they done? Why are they the ones that have been recommended? Because there have been a lot of comments as the list came out. Oh, it's the daughter of a judge. Oh, it's the son of a magistrate. Oh, and once there's a lack of confidence in the judicial system from the point of appointment, that lack of confidence goes with the legal system right through to when the judge actually starts to sit. And then you start to feel, how do I know that the judge is going to give me justice when I don't know how he or she became a judge? So what we're trying to do is to strengthen the system by ensuring that there's transparency in the process in line with the national judicial policy. Let everybody know on the basis of why these people have been appointed or have been recommended for appointment. Then, hopefully, everybody will see that, oh, you've got the right people there. And obviously, if the wrong people are there, then JRP will probably take the next step and say, well, sorry, we don't think that this was the right person that you should have recommended.
So if they respond to your freedom of information request and they send out the CVs, are you going to publish them?
It's not just sending out the CVs. It's also giving us information as to the process. Okay. Were they interviewed? When were they interviewed? Who interviewed them? What did they say?
So are you going to make all of this public so that other members of the community can see them?
Well, we'll cross that bridge when we get to it. Okay. But we'd like to be able to support that process to ensure that it is transparent. We might just look at it and come back and say, well, we think that next time this is what you need to do to ensure that there's confidence in the appointment system. It depends on what we get.